May the representative lawyer of the plaintiff come up and present your argument.
Thank you, Judge. May it please your lordship, my name is Thomas Chen, and I appear here for the repellent of my friend, Mrs. Chen. Today's case is concerned about the breach of the duty owed by a certain party to another party. Before I make submission on the grounds of appeal, would your lordship like to have a brief summary of the facts of this case? I'm grateful to tell you that Sophia Chen, a 6-year-old Hong Kong citizen, is an asthmatic child who died of a terrible asthmatic attack after having a couple of dried apricots, which was produced and shipped to Thailand by a Hong Kong company, Lucky Trading Company. Secondly, on the grounds of medical evidences, the use of preservative sulfide, which has been used in dried apricots, has been the fatal to such damage. In this case, is Sophia's death. The appellant here is now raising the case to the court on 2 grounds. Firstly, there has been a breach of duty of care owed by the defendant, HKSR government, in enforcing its ordinances regarding food preservatives labeling. Secondly, the defendant, HKSR government, also breached the duty of care to control the level of Hong Kong air pollution to a stable level. And here, I'm going to speak about the duty of care and establish the grounds in 3 aspects. First of all, proximity of duty of care. There is sufficient proximity between the government and the plaintiff, Mrs. Chen, in this case. May it please your lordship, I would like to draw your attention to the regulations of food additives in Hong Kong. The Chapter 132W, Regulation 4A, states that all packaged food manufactured in Hong Kong, they're ready for domestic and final consumption, should be marked and labeled with a list of ingredients and the preservatives that's used. Moreover, in the same regulation, Chapter 132BD, Schedule 1A, it clearly states that the food label on the prepackaged food should include all the amount of preservatives the food contains. And for dried apricots, the amount of preservatives that can be used is 2,000 ppm. In Sophia's case, the apricot is prepackaged food ready for both export and domestic consumption. It is therefore submitted that the above-mentioned regulations should be applied in this case, meaning that the government is requiring a food label on the apricot with the ingredients and amount of preservatives that is sulfur dioxide contained and listed. Using the thin skull rule, even our client Sophia may be overreacted to sulfur dioxide to the cause of death. However, the government has no excuse not to exercise the regulating of the food label, as the government has a duty of care to enforce its regulations. Secondly, the second grounds of establishing the duty of care is foreseeability. According to research from the pediatric department of the Chinese University of Hong Kong, there are about 20,000 children are allergic and 1 out of 10 children are suffering from asthma. Together with the poor air quality in Hong Kong, which worsens the frequency of occurrence of asthma-related adverse reactions, especially to children, the government is fully expected to put its whole effort on the food labeling regulation as to protect children that are having a high possibility suffering from food allergy. Without labeling, the parent cannot be effective in selecting correct food for their children, as general public are not expected to have a certain level of knowledge about ingredients. And third aspect in establishing the duty of care of the defendant is the consideration regarding its policy and fairness. Under the current exporting policy in Hong Kong, exporting food are required to pass through inspections by government-related bodies before leaving Hong Kong. When the apricot was exported, surprisingly, there were no customs. What I mean is no inspections. A inspection government body trying to stop the export process with the reasons of the apricot was not correctly labeled. In this case, the failure of the government to detect and inspect the unlabeled apricot and prevent the export of the apricot revealed its negligence regarding the food label control. And our client here was the unlucky one to suffer from such actions. As her parent has no means to trace for the ingredients, the government can only be justified if she is going to be responsible for the cause of damage, which in this case, death of Sophia, on the ground of fairness. As to conclude establishing the duty of care of the government, it is thus admitted that the HKSR government is having sufficient proximity. The death of a girl is a foreseeable damage caused by the negligence of enforcing in food labeling regulations. Probably, the government should be responsible under the reconsideration of fairness and policy. The government owed a duty of care in enforcing its ordinances regarding the free preservatives and ingredient labeling. To conclude my speech, I believe that I provided sufficient grounds to prove that the defendant, HKSR government, was negligent and breached the duty of reasonable care to enforce its ordinances and conduct inspections. Thus, I sincerely request the judge for the defendants the omissions of its actions which led to eventual damages. Thank you.
May the representative lawyer of the defendant please come up and present your argument.
Thank you. The most important element in tort is the duty of care, which my client, the Hong Kong SAR government, does not owe one to the plaintiff. As mentioned by the representative lawyer of the plaintiff, duty of care is determined by proximity, foreseeability, and policy. Firstly, proximity. There is simply insufficient proximity between my client and the plaintiff in this case. My client, as a public body, does not merely serve for an individual but the general public. Indeed, the population of Hong Kong is so large and the circumstances of each are so diverse that it is impossible for the government to cater every single need of each citizen of Hong Kong. But instead, the government could just serve for the general needs of the public. Hence, the correlation between the government's duty of care and Sophia's death is illogical. Second, policy. The actions of public bodies are subjected to the consideration of the advantage of the whole population rather than solely to the benefits of a certain private individuals or organization. When allocating resources and taking decisions at risk, public bodies are likely to be empowered and constrained by statutory authority. For example, you cannot sue the police force when you're being robbed. Or refer to the case of Hill and Chief Constable of West Yorkshire. The police does not owe the duty of care to the victim of a serial killer, given that the police has already done their job searching for the killer. In this case, my client has already fulfilled its duty as a public body to regulate and enforce food labeling to ensure food safety. May I draw your attention to Schedule 2, Chapter 132 BD. The government has already enacted the law to ensure food manufactured in Hong Kong for local consumption is safe for the standards of the general public, while my client has also performed enforcement of such law through random sampling executed by the Hong Kong Center for Food Safety. However, it is impossible and unreasonable to expect the center to examine every single product manufactured in Hong Kong for local consumption. Lastly, foreseeability of harm. The foreseeability of Sophia's death under the present Hong Kong SAR government's regulation and law is low. Government's ordinance on food safety requires each company to put up a food label indicating the amount of preservative used. It is the company's responsibility to obey the enacted law. If every company does their duty, the foreseeability of harming people is low. In conclusion, I provided sufficient grounds to refute the arguments stated by the lawyer of the plaintiff. There is no direct correlation between the Hong Kong SAR government's duty of care and Sophia's death in terms of proximity, policy, and foreseeability of harm. Therefore, may it please your lordships, the government should not have any responsibility in this case.
I do feel very sorry for the plaintiff's tragic loss. However, I realize that Sophia's death had no direct logical correlation with the Hong Kong SAR government, both in terms of duty of care and environmental factor. The proximity between the Hong Kong SAR government and the plaintiff is simply too insufficient, and the foreseeability of harm from the plaintiff does not have a solid ground of argument to firmly establish and support the defendant's duty of reasonable care. The thin-skull rule quoted from the representative lawyer of the plaintiff does apply to Sophia's case, but the responsibility does not fall on the Hong Kong SAR government. What the government can do more is to improve its examination of consumers' goods and tighten the regulations on food preservative to minimize the repeat of similar charges. But in conclusion, the government is not responsible for Sophia's death. Case closed.